Hello, everybody, and welcome to another bite-sized branding show. Very excited to have this subject matter on the show. It comes up very often. So we're going to be talking all about IP and trademarks. We have some great guests on the show as always. But before we jump in to say hello to them, I'm going to toss it over to Grant, who is sitting over there, to tell everyone how the show is going to break down today.
Hey, Bernard, thanks very much, and welcome to our guests and welcome to our audience. My name is Grant Tom. I'm known as the head fire starter of the marketing and advertising industry. And what that means is that I talk to business owners about getting their ideas generated and into the marketplace and making sure that they create value for their customers. I'm going to love today's show because it's going to be full of edutainment. I got to get that word in early because the education is just going to be so intense with Joanne and Mike. We're going to be talking all about intellectual property and how to utilize it in business. So I can't wait to unlock the 3 sessions that we've got waiting for everyone. So let's get started, Bernard.
Awesome. Thanks, Grant. And that's exactly it. We're talking about how to protect your ideas. So Joanne and Mike, thank you both for joining us today from IP Guardians. I think I'll flick it over to Mike. Do you want to tell us a little bit more about IP Guardians, what you guys do and you know, how you help people in their businesses?
Yeah, absolutely. We're a relatively new company, but we've got lots of experience in the employees around us, and at least some 40 years of experience just in myself and my main business partner. So IP Guardian, we're a specialist patent attorneys and trademark attorneys, and also we file registered designs for our clients to protect the intellectual property that they've come up with. And of course, I personally have also got a lot of experience in intellectual property valuation. So I am able to, well, I have a good understanding of how intellectual property adds value to a business every day, from having gone and had a look at, you know, how it's gone and done that in lots of other companies. All right, so I guess that sums it up.
that sums it up. Ready for the first question, I guess. Joanne, you can also say hello to you. Hey.
Hi.
She's so quiet in the corner right now. Cool. Awesome. We'll jump into the first question, and that's really interesting around the value that it builds in a business as well. So maybe we could talk a bit about that within the first question. We really want to explore with this first question, when is the right time to get a trademark? I think a lot of people are kind of mystified by the whole idea. And I'm really unsure, you know, do they do it right at the beginning? Is there, you know, what are the risks of not doing it? So let's jump into that first question. When is the right time to get a trademark in a business? And I'll hit this little timer here. There we go.
Yeah, no worries. So the ideal time to do it, as soon as possible, really, but sometimes that's not always possible because, you know, cash flow, that sort of thing, you know, always a problem when you're starting a new business. At the very least, and it's a little bit like Irish road directions, you know, Irish road directions, if you can see the church, you've gone too far. Really, by the time that you're successful enough that other people might want to copy you, by that time, it should have already been filed so that you can stop them from doing that, right? But realistically, if you've got the budget for it, you got to think about this. You know, you're going to be spending a lot of time and effort on building your business, building the branding in the business, building the reputation of that business by giving the best service and the best products you can. And you don't want anybody else being able to just piggyback off that reputation. And ideally, you want, you know, when you're busy thinking about the name of your business, you want to see if that protection is available for that name right from the start. The last thing you want to do is you know, spend 10 years and then find out that it couldn't have been protected right from day one.
I think that's I think it often is the last thing that people do is actually jump on and have a look whether or not there's somebody in a same sphere as them that is already registered that might restrict their ability to register. I don't think most people even contemplate doing that before picking the name. It's hard enough to pick a name, but
absolutely. Sorry, Joe.
Yeah, go ahead, Mike.
No, he's talked enough. Go, Joe.
Go, Joe. Yeah, go on.
Yeah. What I wanted to say is it happens quite often that some small business owners they was not aware of trademark protection or searching their trademarks was searching for trademarks before they register business name or company names, and they have used the business name or company name for a couple of years, and one day they have received a letter from another company alleging that, well, their business name had actually infringed the trademark rights of another company, and request them to stop using their company name that has already been used for years, which will be quite a disaster for a business, because you could imagine over the maybe 5 or 8 years, a business could have input a lot in building up the brand and the reputation, and the brand is so important for customers to identify the business, memorizing the business. So yeah, to avoid this kind of risk, it's always best to do a trademark search to make sure that the business name that a business wants to register is available to use, and also register it as a trademark and make it yours exclusively.
And there is a direct cost as well. This actually happened, like you just reminded me with that exact story, that there was a friend of mine who was trading here in Sydney. Then somebody in Melbourne had the exact same business name as him. And then they said that he was infringing, and it was hard to prove who was the one who kind of got into market first.
Exactly.
And then he just directly looked at his assets, and he was mainly a digital company, but just to replace the website and the branding, and then, you know, do a little bit of collateral, new business cards, etc. It was like a $30,000 spend. So you don't realize when you first launch the business, because you do it over a period of time. But when you've got to do it all at once, it's a significant investment just to have to rebrand and reposition. And then it's the whole road to re-engaging and informing your clients of the new brand. So there is an investment to it outside of just the intangible.
And there's more than and there's more than that as well. Sorry, Karen.
Okay.
There's more than that as well. So trademarks can be very misunderstood as well. Okay, and badly used. I always say it's like swimming against the current if you're not using a trademark properly, right? You can spend a lot of time and money and effort trying to get somewhere, and you're just not getting anywhere because it's, you know, the IP systems are intended to be used in a particular way.
So then what is the difference between a trademark and a copyright then?
Okay, so copyright's something completely different. Copyright is it's originally was there to protect artistic kind of things, but there's been a bit of an encroachment in the industrial sphere. So there's say around 11 different original works that are defined in the Copyrights Act. Things like artistic works, musical works, literary works, broadcast signals, that sort of thing, movies, photographs, things like that, right? And the idea is that when somebody uses their talent and their skill to generate an original work, so it must be reduced to material form, all right? Can't just exist in their head. Yeah. So you have to create an original work, and then the copyright vests automatically in the author of that work. Yes. And then it may transfer by operation of law, for example, if they're an employee and the employment agreement says that it will belong to the employer, or if there's a contract, or if they die, then it goes to their heirs, sort of thing. Yeah. So now copyright is just that, the right to copy that original work.
Okay.
It doesn't protect you from independent development of a similar work. You know, two artists can come across the same scenery and paint an identical painting. There's no copyright infringement there. They haven't copied each other's original work, right? Yeah. So it's a weak right, but you know, especially when it comes to software, you know, software can be regarded as a literary work.
At the bottom of the website, we always put copyright. Does that mean nothing?
Yeah. So what it means, it's an indication of who copyright in that original work belongs to. Okay. Now, what's strange to me is that people often update every time that they put the latest year. Yeah. When realistically, you want the date that the original work was created, because that gives to show, hey, this was created first. You know what I mean? So ideally, you want to put, you know, every time you create a work, you want to put the C in a circle with either the author or the owner of that work, the person who's got the rights from that author, and then the date it was originally created.
Yeah, cool.
Got a phone call.
We have everything happen on this show. Everything with that clock. Everything.
There you go. It actually
Well,
ended.
that was the end
anyway.
anyway.
Yeah. That's so funny because we always look at the copyright to determine when the site was last updated, and we're like,
Yeah,
oh,
well,
this
let's
site
just
hasn't
know
been
that the
done for
site
6
is
years.
updated with its latest licenses and privacies and security, and yet it doesn't help from an IP protection. That's actually a very interesting point.
Yeah, interesting.
Yeah, and I think again, it's fundamentally it's misunderstanding what copyright is and why it's there.
Yeah,
I got
and there
one
is
last.
some area overlapping between
Yeah.
copyright and trademark. Imagine you have a graphic designer designed a logo for your brand. That copyright of that design is actually belongs to the graphic designer, and in order for the business owner to have the right to register that logo as a trademark, we always recommend the business owner to have the copyright of the logo design to be transferred from the graphic designer to the business owner, so that the business owner could have the right to register it as a
I've got some
trademark
clients
and use that logo.
But I'm going to ask a question, okay? I know we're out of time, but trademark. Now, trademark is about the shape, isn't it? It's like if I trademarked a goldfish, I can't own all the goldfish, but I can own one shape of a goldfish. Is that not trademark?
Trademark could be words, could be a logo, could be a shape of the package. It could be color of the package, color of the product. It could also be scent of the product. So there are quite various form of a trademark, but what are the most common form are word and the logo.
So
And
shape.
dogs. And dogs.
And dogs.
Well, because doesn't Porsche or Ferrari, right? It's yellow and red are, I think, trademarked to Ferrari, and then do hotels, I think, also restrict the
I'm not
use
too
of
sure
their
whether
scent or
yellow
something.
and black are registered color as Ferrari. I'm not too sure, but I can give you an example of color trademark. The 7-Eleven logo, the three lines bands, the three color lines, the green, orange, and green or red. So that is the registered color trademark. So three color as a combination as a color trademark, and also Tiffany jewelry. They have registered the blue,
the teal color.
Yeah.
We actually have a company in our network called Tiffany Projects, and we had to change their color to red because it used to be like a teal kind of color. And Tiffany actually asked them to change the color because it was too close to the original.
No, but Tiffany also went and created their own color, so they went and created that color.
Look.
Well, anyway, we can't. Guys, we're talking out of time now. Okay, all of you, you're in trouble. Okay, I was there too, but I'm not counted. Cool. We'll move on to the next question. Well, actually, we kind of bled into this next question because we started talking about what are the different types of protection you can get. So you're talking about the different color, et cetera, et cetera. But before you talk anymore, let me hit this guy. Otherwise, we'll be here all day. Awesome. Now you can tell me more things about it. Mike, what were you about to say? Tell me.
Yeah, I was going to say that.
Looks like one of your kiddos is coming in.
Yeah, well, they're all coming back from school now. So essentially, for a trademark, you can get protection. Oh, by the way, you can actually get protection for a sound as a trademark as well. Yes, basically, anything that's capable of being graphically represented. So a trademark, as I say, protects any. Once you've got registration for a trademark, nobody else is allowed to use the same or a similar mark for in the same or a similar class of or field of business, class of goods or services, right? So they can use it in a completely different field of business, but not in the one that you've got it registered for. And that inherently is the difference. Going back to that ASIC registration, that just gives you a company name. It can be almost identical to another company name, right? The two of them can exist co-independently or alongside each other as long as they're not in similar fields of business. You know what I mean? But it's only the trademark that gives you that protection.
If you try and extend that trademark to other industries, can people then what's the word I'm looking for? Like,
Yeah, sue you. Can
sue you, yeah, for saying, okay, that's not the industry that you're in, or can they put a dispute up to say, well, we're not in the same industry. We want you to like not hold the trademark in our industry anymore.
26
Absolutely.
classes.
So if you've got, if you've been selling milk under the name Anchor for a while, and then all of a sudden you want to go into floor polish, and there's an existing trademark for Anchor in floor polish, then yes, you'll probably get a cease and desist letter pretty shortly, to say there's possibility of deception and confusion here.
And vice versa.
What about
you can't get a trademark and then think you're protected in all categories. You can just do what you like. You've got to choose the case in which you are getting your trademark in.
Yeah, and this is also why I think trademarks are badly understood. So if you file it in, so they work commercially and they work legally. Commercially, what happens is that it every time a customer has an experience with your goods or services, it creates a little bit of reputation, and that reputation sticks to the trademark for want of anything else, right? Now, the more distinctive and the more memorable that trademark is, the more sticky it is to that reputation, right? And that goodwill, and the quicker it builds up on that trademark, where it could become a capital asset of your business, and people might want to buy your business to be able to use that trademark. Can you imagine how many Chinese jeans manufacturers would love to be able to put Levi Strauss on their jeans? They could triple the price of their jeans overnight, because it allows you to add that premium because you've got this reputation, right? And so that's one way that it works commercially. And in order to use it properly commercially, it's got to be distinctive. It's got to be memorable. If it's descriptive of the goods or services themselves, it's not descriptive. I mean, it's not distinctive, all right? Because every time your competitors use descriptive words to describe their products, it's diluting your trademark.
Yeah.
Right? So,
like if you're a Sydney carpenter, then you can't trademark it, because all the other Sydney carpenters would also want to write Sydney carpenter on
they
their
also want to
website.
say, I'm a carpenter from
I'm a
Sydney.
carpenter in Sydney. Yeah.
The rule of thumb is, if your competitors could be required to use it in the ordinary course of trade without infringing on yours, then it's probably not available to you as a trademark, right? The other way that it works is legally. So we'd file it in that particular class of goods or services with a specification of goods or services that it's going to be used on. And the net result of it getting registered there is that nobody else can use the same or similar one in the same or a similar class of goods or services. So if I'm a grocery store owner and I'm going to be filing in the class of goods or services for fresh produce or sales of fresh produce, I can't get the trademark pineapple or cucumber, because if that was to be registered to me, that would mean no other grocery store owners can use the words pineapple or cucumber. So they have to be able to advertise what it is that they're selling, right?
Back on the last question that we had in a slightly different context. So let's say it is Coca-Cola. Can Coca-Cola legally register in the class of construction if they decide to in the future do developments, or are they restricted to the classes that they currently provide? So if another, for example, somebody starts their business, calls it Coca-Cola Development, and develops properties.
You want to answer that, Joe?
Yeah, I think this is a very, very good question. It can extend to quite different topics about trademark. So, so for example, if another company, not the Coca-Cola company, wants to use the Coca-Cola as a trademark to do constructions, technically, yes, it is able to do so, because from our general understanding, Coca-Cola is a beverage company. It may also have food products like snacks and some other beverages of drinks. That's the general understanding that what Coca-Cola brand is about. However, as Coca-Cola, the original Coca-Cola company, because it is so famous and because it is so well known globally, in Australia, Coca-Cola, based on its huge reputation globally, it is able to register defensive trademark registration. With defensive trademark registration is, even though Coca-Cola does not do construction, does not build any building properties, based on the huge reputation, it is able to register its Coca-Cola brand as a trademark in relation to construction services as a defensive registration to avoid any other company to try to pass off their reputation or try to confuse consumer that any other company who wants to be called Coca-Cola but provide different services or sell different products is related to the original Coca-Cola brand.
Do you think this would not be available as an option for Tiffany per se, because Tiffany has a name that is a name? Like, would Tiffany also get the same option as Coca-Cola, or?
Well, in order to register defensive,
we have to hear the answer, Grant. We can't stop now.
So in order for Tiffany to register its name as a defensive trademark registration, it has to demonstrate its reputation. So it really depends on what kind of evidence that Tiffany could present to the trademark office to support their reputation. It may be able to register it as a defensive trademark. It may not. It really depends on the evidence of reputation that they could show. But I think the chance would be good because Tiffany, it is also a globally well-known jewelry brand.
Yeah, there's typically most countries have got protection for internationally well-known brands, where, for example, people might try and again piggyback off their reputation by trying to or alluding to some sort of what's the right word?
Tether or link to the
link between the two companies. So if I start manufacturing lawnmowers and I call it Ferrari, you know what I mean?
Yeah,
that's going to be a no-no. You know, it's just
I like it
because
Ferrari mowers.
Yeah, right. You know, and essentially what you do, what I would be doing in selling Ferrari mowers would be diluting the internationally well-known brand name. You know, and they'd probably have a cause of action against me for that.
All right, but if I had to create like a Ferrari brick, right, and now be in the construction business, and I called it Ferrari, what would Ferrari do?
Look, I think if there's any reason that, you know, if they have any reason to think that you're trying to allude that there's a connection or something, you know, tether in industry between the two, they would be all over you like a rash, right?
Yeah.
And that I believe that's the case for most internationally well-known brands. They've worked hard to establish those brands. They're not going to have it taken out from under them.
Yeah.
So you're saying don't stamp them with the logo. That's what you're saying. That really is too far.
But it's also saying make sure that you get your protection in early in order to validate your endorsement as to your value, as to who you are.
Cool. I don't think we've broken this many rules in a show for a long time, Grant.
Sorry, I know we're going off topic a lot. But,
No, not at all. It's great. It's great. The information is so like. I don't think we've ever dug this deep on this particular subject before, which is really.
Well, that's why I had to get edutainment that word in early, because there was no way to get it.
Yeah, that's it.
Actually,
awesome.
Just going on that branding, you know, digging a little bit deeper. What I also find from IP valuation is so you've got your brand, which the reputation sticks to, but the reputation is caused by the underlying sort of brand support intangibles, right? Like for Coca-Cola, you've got the distribution system. For Toyota, you've got either the design or the after-sales service system that they've got in place, right? It's not just, you know, Coca-Cola is not such an amazing brand just because it's a nice white ribbon, you know, on a red background, right? It's there because of some other reasons, because you can find it on every street corner in the world, right? And what I've seen also is when you've got like a branding or marketing type marketing campaign that also aligns with those brand support intangibles, it can be very effective.
Yeah. Interesting. All right. So you gotta get started.
Last question, and then we'll wrap this baby up. It's been a phenomenal show. So the last question we have actually is, with a lot of changes that are happening out in market, new technology, new platforms, new environments that are being designed, what is changing or evolving in the trademark and IP space to kind of synchronize what's going on out there in the in the great big wide world. I'll hit this baby and ready to go.
What's happening to synchronize it? Gosh, do you want to have a go at that, Joe?
Yeah, I think so with the technology advances, people are recently talking about metaverse, web 3.0, things like that. And we've seen a lot of large companies starting to think about seeking protection for their trademark rights in relation to digital assets. For example, with Meta announced considering launch a metaverse platform, and Burberry and the Prada are considering launch their branded digital fashion designed for avatars being wearable on Facebook platform, things like that. They are considering expanding their trademark protection from the very traditional fashion item to the digital fashion items in order for their brand to be protected in the digital world. That is the current change that we have recently seen in the last few years.
I think that's crazy. I just think that is so crazy, but yet so vulnerable that if you do not protect your intellectual property in another sphere, other people can hijack you, and therefore utilize your essence of your value in another dimension, and that you can't claim value to. I think that is so crazy, but so important.
I love how you just called it another dimension. In another dimension.
It's a whole new world.
We were talking earlier. I think Mike, you mentioned something around also AI, or a case around intellectual property, was it, or something like that?
Yeah.
How is that impacting the trademark and IP space?
Yeah. Well, not too much impact on the trademark side of things, but certainly around copyright. There's design, and also around patents. So patents are there to protect inventions, new and inventive technology. But there's been a recent court case, Thaler versus Commission of Patents, which actually got appealed and it was decided, where there was an application for a patent, and the inventor was actually named as Dabus, which is an AI, and the commissioner said no, an AI cannot be an inventor.
This guy was foolish. He should have just written his own name. The AI is never going to come to him one day and be like, "You stole my idea."
I think it was the principle of it, it was just pushing the boundaries a bit, right? And and anyway, it went to court, and initially the court decided that the AI can be an inventor, and then it was appealed by the Commissioner of Patents, and then the next level said no, it can't be, which I tend to agree with. I don't, until AI is actually sentient, which it isn't yet. It's still just a tool. It's a very sophisticated tool, but it's still a tool, right?
Yeah.
It still takes somebody to set up the AI, to set up the machine learning model, to set up the neural network and everything, decide what it gets trained on and that sort of thing before it can do come up with an invention.
But here's a challenge, right? Yeah. Here's a challenge. Like, you go to AI and you say, design me a game. It will design the game for you. And then you say, give me the rules to the game, and it'll create the rules to the game. And then you say to me, write the code to write the game, and it'll write the code. So technically, it is, I understand, scraping, but at the same time, you're asking it to conceptualize a game.
I'm not sure if that's actually been done to come up with a game. Can it actually come up with a game that it's not that it hasn't already been trained on?
Yeah,
you know what I mean.
Yeah, I think that the thing is that it's like an adaptation of something that it already knows. But then again, but then it begs the question: is not everything that we create these days an adaptation of something that already existed?
That's a very good question. Yes,
Very much so.
that's how we progress as a civilization, right?
I once asked somebody, I was like, "Do you think we invented the plane?" And they were like, "Yes." And I said, "Weren't birds flying before we did?" And I was like, "Oh."
Similar principle. Yeah, we certainly didn't invent the wing.
No, we did not invent the wing. That is true. Yeah. And that's where it becomes very blurry within that space, right? Because in the end, if you think about it, a child only knows how to invent something when it's an adult only because it was taught things as a child, much like your AI is being taught things by inputting data into it, and it then uses that data in order to apply it to something.
Yeah. Perhaps there's a distinction to be made between an incremental change and a revolutionary change. Perhaps that needs to be the difference. You know what I mean?
Yeah.
Because anything that really changes the way we think, you know what I mean? That's something that really comes from imagination, and that's just something that machines don't have, at least yet.
Yet.
You know?
And hopefully never, because we've seen Terminator. Okay, like that doesn't end well for us.
Yeah, there's also you asked a little bit earlier about AI impacting copyright. So there's been a lot of uproar as well around machine learning or AI modules need to be trained up on things for them to understand and to understand the patterns in all of those things, right? So that they can then make predictions on other things, right? So for example, I don't know if you've ever seen that DALL-E, which is the visual version of ChatGPT, where you can say, paint some, or give me a photograph or a painting, make a painting of red and yellow balloons in a cloudy sky in Van Gogh style or something like that, right? And then what it does is it goes and generates this thing in 10 seconds, but it's amazing because it's but the issue is that in order to train it up, you have to feed those copies of the original paintings into its learning systems. And I think a lot of artists are going, hey, I don't want my original works being used as a basis for your style,
That's where NFT
learning.
steps in, that you can get a royalty for every time something of yours is getting used. So then the
See,
blockchain.
that'd be cool. I don't think the artists will be unhappy about that if they start getting paid for it.
Yeah, a royalty for every time they're getting used.
Yeah, it's not a bad idea. Mate, Grant, we should just put you up there. Who's designing all this stuff? Grant should be running this joint. Right?
There we go. I think so.
The president of the meta world.
Yeah, but then there's arguments around, so if it generates a new painting, is that a copy? You know what I mean? Because that's what copyright protects, a copy. So how much of an adaptation does it have to be, or how similar does it have to be to the original?
Or who owns now the copyright?
Well, that's the other thing. Who owns the copyright in what it generates as well?
Because it kind of lends back to your point before. If you had a group of artists all standing at the exact same perspective on a landscape and they all painted the landscape, aren't all their paintings going to end up relatively similar anyway? So then just because you input a picture into AI and say, can you make this painterly like in the style of Van Gogh? If that was the style that you had been trained as a painter, you would also paint the same scenery in the style of Van Gogh. So where does the line get drawn there? Because it's an original work.
Well, the line is in what are you copying? If you're copying the scenery itself, that's not an original work. If you're copying an original work,
then it is.
Then it is copyright infringement. So, but then how much of a copy does it have to be?
You know what I mean? Artists will get that instant copyright because of the self-generational foundation of the artwork.
Yeah, but it's not actually generating the same work.
But if they create something that is validated by them, then it's theirs. So if 11 artists in a row paint a landscape that is not copied, but it's their interpretation, then technically all 10 artists should get their copyright attached.
Yeah, absolutely. There's copyright in each of those paintings, yes.
So I figured it out. So the problem is that the AI doesn't have eyeballs. If the AI was accumulating the information on its own, then we couldn't really stop it from replicating the work, because it would be original works based on what it adapted, like what it had consumed.
One artist feature here.
Yeah, but this is the thing. It doesn't do it by itself, right?
Yeah, it doesn't.
Somebody feeds it in.
Yeah. Okay. Okay. Let's put us on a panel at in a courtroom with the next,
Oh, we'll kill it.
AI course. Guys, this was a phenomenal conversation. I absolutely loved it. I think Grant loved it. That was phenomenal. Grant, mate, before we wrap up, I'll throw it back to you and do a little wrap of the show.
Look, I think that this is a good example where we broke all the rules, but technically that's how robust the subject really is. That there is so many caveats in the sense of where there's opportunity and where there is areas for you to get protection. I think as a business owner, you've really got to think very carefully in the space that you play as to what you really want to become within the category that you are, because technically your hard work should be protected. And this is where we've just tried to unbundle the importance and the relevance and the future of where your intellectual property will go, even though we are transferring into other dimensions. I just want to say that this has been a fantastic edutainment segment, and I'm going to walk away boosted. Thank you.
Yeah, awesome. Thank you, Joanne and Mike. That was incredible, and I think actually it's posed a lot of questions for people. And if you guys, anyone that's listening and watching the show, if you do have thoughts on the stuff that we talked about, because there were a lot of open-ended subjects here, would love to hear your thoughts and perspective around copyright and trademark, AI and the metaverse. How does this all kind of play, and how do you think it might play out? I'm very excited to kind of see what everyone comes back with and their thoughts. Guys, any last words you've got?
I would like to say thank you so much, Grant and Bernard, for organizing this show. And you have asked very, very qualitative questions. It is rare for me to go so far explaining trademark subjects to clients, but it is good to share that kind of information and knowledge to all the audience watching this video.
Yeah, so when this comes out, what we could do is we'll give it to you, and then every time you onboard a client, you just send them this video. And be like, here's everything you have to know.
I'm more than happy to show it to all of my followers on LinkedIn.
Awesome. Mike, do you have any last words?
No. I think Joe said it all, really. Thank you so much for inviting us, and we really appreciate being on the show.
It was amazing.
There's honestly, you can keep talking about IP all day, really. There's so many different things to talk about, and fundamentally, fundamental philosophical questions that you're sort of trying to get to the bottom of. But
you definitely can't do in 7 minutes. Guys, thank you very much. Anyone that is listening, watching, if you do have interest in this or you are starting a business, please reach out to the guys at IP Guardians. They'll be able to help you get everything set up correctly, and make sure you do the due diligence you need to do before launching a business, so you don't end up in trouble down the track. For everyone in general, thank you very much for listening. Thank you, Grant, Joanne, and Mike, for joining us. Please like, comment, share. Especially on this show, we really want to see your comments on these topics.
We want to see a lot of
bloody hot, man. I want to know what's going on. Yeah. We want to see a battle, a rage. And then if you have any guests or topics you would like us to unbundle on the show, please send them through. We're always excited to hear from you guys. And if you'd like to feature on the show, please reach out directly. You can DM either Grant or myself, or reach out by email, and we're happy to feature you on the show. Other than that, I think I got it all. Anything else, Grant?
Look, I just think that this is a show that we're going to have back, because we haven't even scratched the surface.
Yeah, I think so too. I think it'll be good to unbundle a lot more of this, especially a little bit further down the track as we start to see what fleshes out around the metaverse and AI, etc., to see how it might change or impact the industry or the space. Guys, again, thank you very much. Thank you very much, Grant, and we'll catch you all on the next show.
Thank you.
Thank you.